Welcome to Glow for Hope, sparking conversation on mental health, where we break the silence, build community, and ignite hope. We're here to talk about what really matters: mental health, wellness, and the conversations that help us all feel seen and supported. Every episode will bring real stories, expert insights, and practical tools to help you navigate mental wellness and suicide prevention. Because together, we can change the conversation. Let's get started. Welcome back to another episode of Glow for Hope, sparking conversation on mental health. I'm your host, Kelly Pelker, along with the fabulous Delisa Richardson. Delisa,
Hey, everybody.
how are you doing?
I'm good. How are you?
I'm good. Excited about our guest that's coming up.
Yes, today we are joined by Jacy Fisher. She's an attorney and a judge advocate in the Alabama Air National Guard, and she bridges family law, estate planning, and advocacy for vulnerable individuals and families. Jacy has a deep understanding of the law, and it combined with her background in psychology, it gives a unique perspective on how the legal system works. And we're really excited to have her today because we want to know about how the system works when it comes to impacting families, navigating mental health challenges. So, like Kelly said, in this episode, we're going to talk about the legal side of mental health care, from parents' rights and guardianship to involuntary commitment and long-term planning. Jacy's going to help us give an understanding of what parents and caregivers can do, what they can't do, what they should do and should know when supporting a loved one through mental illness. Jacy, thank you so much for joining us today on the podcast.
Absolutely. I'm super happy to be here to talk about this important topic with y'all today.
Can you tell us, let's just go right in. Let's talk about minors for a moment. Let's talk about parents' rights for minors. So, what legal rights and responsibilities do parents have when they're seeking mental health treatment for their children, or if the child has to be hospitalized? And are there any limits to the parent's authority in these type of situations?
Yeah, so it's a little bit easier to deal with when your child is a minor as opposed to an adult because you do have custody or natural guardianship over your child in most cases. Of course, I'm an attorney licensed in Alabama where fathers do not actually have custodial rights until a court adjudicates them or orders that they have custodial rights when they're not married to the mother, which is an interesting concept. Because if you are a father that has, your child living in your home and you're not married to the mother, you actually have to have a court say, yes, you are the father before you can really exercise your guardianship rights. But let's say for mothers in our state who are assumed to be the guardians of their children, even if they're not married, it is a little bit easier to seek the assistance for the minor child because you have the authority over them. And I will speak to kind of situations that we've seen in the city that I live in and the area that I live in. Um, you know, there is absolutely a mental health crisis for minors happening right now, specifically in not just high school, but in middle school. And we have seen a number of children with suicidal ideations or suicidal behaviors. And of course, the parents want to intervene as much as possible. And so, at least in our state, we have not had an issue with parents being able to get their children the assistance that they need, whether it is through hospitalization or signing up the children for therapy and counseling. They have not had many issues with that over here. But the other thing that I will add is, as a community, we have to ensure that the parents are not alone in taking care of these minor children who are dealing with mental health issues. One thing that we as a community are trying to do is we've established, a mental health action committee. So organizations that are really taking more of a village mindset and effort to invest in our minor children and their mental health. And that has made a significant difference because I do feel like the parents can only do so much beyond trying to get the children treatment hospitalizing the children for mental health if they absolutely need to, if they're a danger to themselves. What happens when the child comes home? What happens when the child has to go back into the school system where they're being bullied every day? And so I would say that is one of the limitations that we see, is that the parents can feel isolated, like they don't have a deep sense of community from their village, from the children's school. That's a big complaint that we also hear, is that the schools are not supporting these efforts. They are allowing the bullying to continue. They're not intervening. And so, a parent can do everything they can try to do with their medical authority as the custodian, but if the village doesn't rally behind the family and the child, there's really only so much the parent can do to help their child.
And that's not just in Alabama.
Right, I believe it. I totally believe that is probably an issue nationwide, and it's really sad when you see middle schoolers. I mean, 11, 12, 13 years old committing suicide because they feel like they have no other alternative.
Mhm.
And so many times there's bullying involved. There's a lack of community, a lack of that village mindset. And so that's something that, like, I'm pretty passionate about. My husband is a city councilman. We don't have children of our own, but we think it is very important that we act as part of that village to help the kids around us, because we consider them to be our kids too, like the kids in our community are our kids.
That's a great point. I want to kind of stay on this for a minute. What can parents do legally, if anything, when you're dealing with a school system who is just not supportive? I know we had a situation like that with one of my children. I ended up having to take them out and just homeschool. But are there any legal ramifications if the school is just completely negligent and failing to protect a child who is going through bullying and they know that there are mental health issues involved?
Yeah, that's a really difficult topic. I actually just got a request today from a parent that was like, we need to intervene. There's, a real issue in this particular county school system with bullying. And so I will say this, like, federal law does, protect a lot of just children with mental health challenges generally. And so when a school is unresponsive or dismissive, parents aren't completely powerless. I will say the most common thing that we see is the parent pulls the child out of school and goes into homeschooling. But the schools then are not on the hook for being dismissive. And so there are a couple things to keep in mind when we talk about federal protections. One is an act called IDEA. It's the Individuals with Disabilities Education Act. It does require schools to evaluate children who are suspected of having disabilities and provide certain special needs services for those children. That's what we know most common as the IEP. And I bring that up because I do believe that there are some schools that are failing to do these proper evaluations, or they're saying that they're understaffed. And so what we're seeing as kind of like a cyclical effect is that because the children are not being properly evaluated, they're not being provided the services that they need based on their disability, they are in classrooms that are not conducive to their learning style, and it's causing mental health issues based on that. And so that's one thing I want to note. But there's also the Rehabilitation Act, which requires schools to provide accommodations for students with disabilities. And this is where we're talking more like, extended time for test taking, counseling, a reduced homework load. They're supposed to have like things like sensory breaks and things like that. And unfortunately, I'm just going to be frank. We are
Go for it.
in, yeah, we are in a time right now where when a child says, or, we want to say that a child needs a safe space, that is considered woke, quote unquote. And so, like, if they need things like sensory breaks, they're overstimulated, or they need a safe space, like, we are seeing school administration say, well, that's just part of the woke agenda. And like, we need to go back to the old traditional ways of raising kids in school. And so there is no emphasis on like regulating emotions and concentration and social functioning when we're in a time where it's like, you sit down, shut up, only use the bathroom on your lunch break. Like that's it. Like these are the rules and you need to follow them. And so again, that is a violation though of I think it's section 504 of the Rehabilitation Act. And so I've seen some of that also. And then obviously we've got the ADA, which is the most common act that everyone knows about, the American with Disabilities Act. And it does prevent schools from discriminating against children with disabilities, including mental health disabilities. And so when you're talking about legal ramifications, what can parents do? Against schools when they fail to intervene and do their job. These are some of the acts that I know lawyers will cite when they sue the schools for failing to comply with federal law.
You can't hear me on the podcast, but I'm just sitting here shaking my head.
Yeah,
Yes.
totally.
It's like, oh, but now does a lot of what you just mentioned is
Hmm.
disability act and people with disabilities. They wouldn't necessarily classify children with mental health challenges under disabilities. So does that not throw that out the window?
No, it just depends. And see, that's the problem is like a lot of people don't know that there are mental health disabilities that are covered under the ADA. But unfortunately, and this is one of those things that I think is important. I think there are a lot of parents who are hesitant to have their child evaluated for whether they have an actual disability as defined
Mhm.
under the ADA. Because I mean, I'll just give myself as an example. Like I probably had severe ADHD as a child. I was in that gifted program, remember in the 90s, like all the kids that were neurodivergent went into the gifted program. But we didn't call it neurodivergence or, ADHD. It was just like you were struggling in the environment you were in, so you went to a gifted program or a gifted school. And so like I was never actually evaluated for any of that stuff. Now as an adult, I like found out pretty quickly I probably need to get evaluated for this. But there still is this stigma of parents like not wanting to get a formal evaluation, not all parents, but some not wanting to have their children like formally evaluated as to whether they have a disability as defined under federal law. And so, and then with that said, there's also when we think about disabilities, we don't generally think about mental health as being a disability, but there are mental health disabilities. And the public, and I have seen this with the school administration, they only think of like physical disabilities.
Mhm.
Like that is all they're really thinking about are like, what are your physical disabilities, especially when we think of the ADA. But I mean, technically, you can have a mental health disability as defined under the ADA. It's just that I think there's like a lack of testing for that. Then I also think that depending on where you are, maybe it's not geographically based, but um, there are some medical professionals who are quick to say this child just wasn't reared properly. Like this child just wasn't, disciplined enough, and nothing's wrong with him or her. They're just acting out. They're testing you. Um, I I want to give an example actually, because it's public knowledge now. I had a case. This child was not even two, I don't think. Um, we've all heard of sleep regression, right? So, children who will not go to sleep don't have regular sleep schedules. So these loving parents, they take their child to the pediatrician and they say, "Look, our son is not sleeping at all. I mean, he is just like totally acting out at night." And she's like, "Okay, well, put him on this many milligrams of child melatonin, and you cannot co-sleep with him. Like do not co-sleep with him under any circumstances. You've got to go through this training with him." Well, the long story short of it is that this child had autism, and had what we call self-injurious behavior, SIB. And so the parents had no clue. The pediatrician was like, look, I mean, this is what kids do. This is what babies do. You just need to get over it. One day they woke up, the child had, to soothe himself, had been banging his head into the edge of his crib over and over and over overnight. So when the parents got up to go pick the child up from his crib, he was completely bloodied and blue and black, although he was not crying. He was
Wow.
just continuing to bang his head into the rail. Well, 3 years later, after they had not had their child in their custody and I was fighting for them to get their child back and to prove that they didn't abuse this child, it was determined by the court, the experts, and everyone else that this child had this self-injurious behavior diagnosis. But it took 3 years and a quote unquote expert child abuse pediatrician at Children's Hospital to continue contesting that anything was wrong with this child. They just said, listen, there's no way that a child would would engage in this kind of behavior. The parents had to have abused him. There's nothing wrong with him. And we put cameras in his room for 24 hours after the child was placed with the grandmother. We had over 24 videos showing this child banging his head into his crib over and over and over at the age of 2. And so it's just an example that even an expert child abuse pediatrician that's at Children's Hospital for the purpose of diagnosing child abuse maintained even after the court said absolutely. We've got 24
Wow.
something videos. She still to this day, and this is why we sued them in federal court, she still to this day says there was nothing wrong with that child. And I mean, we had expert diagnoses that he had SIB. And so that's kind of an example of like, they even the medical professionals sometimes are not like willing to acknowledge the mental health issues in children, and that they can actually be disabilities and disorders.
That's very true right there. I know with I have a son with ADHD, and at first it was very difficult to get him diagnosed properly so that we could get in the system and get him his IEP and everything. And I actually had to learn about that outside of the school system. Someone else told me about it. Now, with one of my other children, it was anxiety, severe anxiety, OCD diagnosis, and we were able to get that into the school. So there was a 504 plan set up. So yeah, with some, I think it's just depending on where your doctor is, the school district that you're in. They were
Mhm.
very accepting and they were following what needed to be done. So that is, I thankfully had a easy time with that mental health diagnosis in dealing with the school, and then stayed on top of them to make sure that they were doing what they were supposed to be doing. But then when it came to the bullying, that's where it kind of broke down and we had to do what we had to do. But so once, let's talk about the transition into adulthood
Mm,
for kids. Let's say kind of a hard turn because this is where
yeah.
it gets really murky. So what changes occur legally, when a person with mental illness turns 18? You've had your kid, you have all these things into place with, the pediatrician and everything, and then they turn 18.
Yeah.
What do the parents or caregivers do? How do they maintain that involvement in their care, in their decision making? What rights do they have? What are they capable of doing or not capable of doing?
Yeah, absolutely. So I just did one of these recently, and I've done several of them. I will say this, in Alabama, adult guardianships for parents, they have made that process significantly easier. And I don't know about the other states, but now the process is significantly shortened. Like when we think about a standard guardianship for like an elderly person, that process takes a lot longer than an adult guardianship for a parent who is filing for an adult guardianship over their child who already had a disability. So this is kind of how it works. And I'll also add that in Alabama, the age of majority is 19, not 18, which is really interesting. So yeah, you at least have control until they turn 19. But it's one of the most like misunderstood legal processes, I would say, that families face because um, you have to plan early. That's one of the best pieces of advice I can give. The most successful adult guardianships I have seen were the ones where the parent knew that, hey, my child's about to age out or, reach the age of majority in about a year. We need to start planning for an adult guardianship so there's no interruption in care and treatment, especially for those children who may be in like a transition home at the time. And so this is the process. The adult guardianship is a court authorized relationship, so it does require a court to declare you the adult guardian, but it gives the parent legal authority to make decisions for what we call the ward on the legal side, which is the adult child. And so some of the most common examples we see where an adult guardianship is likely to be granted is if the child has intellectual or developmental disabilities, dementia or Alzheimer's, severe mental illness, so schizophrenia, um, severe bipolar disorder, things like that. We often see it with TBIs, so like traumatic brain injuries, where they really they need assistance with handling their personal affairs. And then any type of neurological impairment, we'll see these are all good reasons for an adult guardianship. And I want to add that the goal is not punishment, it's protection. And so I have had to actually explain that to some parents that I think misunderstand their children's diagnoses. And then I question, like, are you even the right fit for this, this adult guardianship? Because some of them look at their children's mental illnesses as like deserving of some type of punishment and control. But the whole point is protection. And so for those adults those parents who have been really protecting them their whole lives, it's a great tool to continue doing that in adulthood. And always remember that the court is going to try to balance autonomy and safety. The goal is to give the adult child as much individualized autonomy as possible so that they can be as self-sustaining as possible. But the court is also going to consider the fact that like there are just some safety things that need to be in place. And so parents need to remember that, if you had guardianship and control as a minor, you're not going to automatically have it as an adult. You do need to seek that adult guardianship. And what are the grounds? Well, there's really two things. So, number one, can the ward make full-blown medical decisions for themselves? Can they understand the medical decisions that need to be made for themselves? Oftentimes, with severe disabilities, the answer is no. And can they manage their day-to-day needs? What are those day-to-day needs? Food, shelter, safety, hygiene. Like those are the top four things the court is going to be concerned about. And if those are things that the adult child cannot manage on their own, a court is very likely going to find that a guardianship is necessary. I have had them last pretty quickly, not take too long in the court system. I think the fastest one I ever had was like 3 months. We filed the guardianship. The adult child was served with the guardianship. A guardian ad litem was appointed. This is an attorney typically who would represent the adult child. So they get an appointed attorney to represent them. And that guardian ad litem is responsible for talking to the child about their desires, seeing what are their actual needs, talking to maybe their caretakers or if they have like home assistants or psychologists, doctors, therapists, having those conversations. A physician letter is often required to say whether or not that physician thinks that the person is in need of a guardian, and what their medical and disability needs are. And then there's typically a hearing if the adult child disputes the guardianship, but also if the adult child is in agreement. I mean, any good judge is going to kind of require that the adult child have an opportunity to speak for themselves unless they waive their presence or the guardian ad litem waives their presence. Or they're not able to actually speak for themselves, which that is the case sometimes. And the court's going to want to make sure that this guardian, like the person who's serving as the guardian, is also a person fit to serve as a guardian. Because just because you're a parent biologically doesn't make you a good guardian, right? So a good judge will want to put a face to the name and make sure that they're asking them the questions like, listen, are you prepared to continue serving as this person's caretaker, possibly for the duration of their life? And testing that, because unfortunately, we do know of cases where there's a guardian or conservator who does not have the adult child's best interest, or not just the child. I mean, it could be a sibling, right? It could be a sibling, it could be a parent that you're seeking guardianship over, and the court wants to make sure that you are the best fit for that person.
So that's all good when there's a parent involved or a
Mm-hmm.
sibling involved.
Mm-hmm.
There's also the whole world of foster care and kids who are wards of the state.
Yeah.
How does it differ, and what happens to those kids?
Ugh.
I do know in some states, like my daughter
Yeah.
worked for she ran an independent living program, which I think was wonderful, that in her state, that they did continue to support the kid, or the young adult, as they entered into 18, and taught them to live on their own and set them up in things, and in housing and cars and all that. But not everybody has that.
Yes. Yeah. Those are the most devastating cases for me. I recently got out of, I know in Illinois it's like DCFS. In Alabama it's called DHR, the Department of Human Resources. Um, and I'm at war with them. It just is what it is. But and it's not a secret either. It's kind of all over the news. But I there's a book that just like immediately came to mind when you were talking about this, and it's called Trash, and it's really sad. It was written by an attorney, or someone who worked in the DHR system, who would see children bounce from foster home to foster home.
Mhm.
And it's kind of like a metaphor for the trash bags that the children would carry from foster home to foster home. And it is, first of all, it's a children's book, and it's very moving, number one. But that is the best way that I can describe how the system treats teenagers who do not have that village, right? Like that, I guess that's what we call it, because it's not just parents. You're right. Like if they don't have a grandmother, if they don't have an aunt or an uncle, the system deeply fails them at that point. And unfortunately, the cycle that we see, and this is coming from now the criminal defense attorney side of me, because I am a general practitioner, we often see the cycle of they go straight from foster care into adulthood into the criminal justice system. That is what typically happens. I'll just be 100% honest. And the issue that I see, the biggest and my biggest criticism of the system, is that DHR says, yes, we want to provide services. We want to provide protective services. We want to provide all these services for these children and for these families. But when they reach a certain age, almost every time it's like, they give up on them. And I do want to say that I understand that the state has limited resources. I get that. I understand that DHR has only so many resources, staff, they are understaffed, underpaid. I get that. I've heard that a million times. But my concern is that you can't say you're deeply concerned for these children, and you want to help, and then discard them when they reach a certain age and it's like, oh, well, whatever happens, happens. Or if they're being physically or sexually abused in their foster home, ignoring that that happened and then placing more children in that same foster home. Like there's just all these issues. And then again, and then you're victim blaming because you're like, oh, well, this is a troubled child. So, she's probably making it up. Like
Right.
there's,
And so many of them even are like, even though they've reached an age, their mental,
yeah,
their IQ and their mental capacity is nowhere near
yeah.
the
And
age
and
that
they haven't
the birth
provided the
certificate says.
services. Yes, they
That's
haven't
just so
provided this.
I'm sorry. That
You
that
go.
that's so devastating to me because I can just see, if the process was done correctly, you have someone in the system, they're on their medication, they're doing well as a child, even in the foster care system, let's say best case scenario in the system, and then they turn 18 and then boom, it's done.
Hmm.
Yeah, and that
That
is what happens. Like they do have they say they have transition programs, right? And we know of some that do exist, like where they will financially like support them or things like that. But in my opinion, what I'm seeing is that they're not really equipping them with the tools that they need to have individual autonomy, like as soon as they reach the age of majority. And again, I hate to bring up that case, but obviously it scars me a little bit about that child with the SIB, the self-injurious behavior. DHR never provided services for that child. Like they stripped
Wow.
him from his family. They said that these parents should never get this child again. And not one time after he was diagnosed with autism did they say, okay, we're going to provide these services for him. Those parents had to pay and get and seek out those services from outside experts in order to get him the treatment that he needed while he was in DHR custody for 3 years.
That
And
is
so
ridiculous.
like and that's the thing, like I can understand making them pay for it, but DHR like never like sought the experts to help him or the treatment to help him. And that's what we see at all ages, but especially when those children reach the age of majority. It is literally like we're done. It not our problem anymore. Like it's not our problem. Somebody they will figure it out, or they're just gonna go be homeless, or they're gonna go right into the system. And I mean, more times than not, they just go right into the criminal justice system. We have seen literally like dealt with a child in the juvenile system at the age 16, 17, and a few years later, we're representing them in a criminal case as an adult.
I
It's
saw
it's just right there.
the rate of recidivism.
that's just so
Yes.
sad.
It's very sad. A lot of broken systems out there, and it's sad that's one of those. It's a whole nother episode,
I know,
Yeah.
right? It
and we
scares me.
probably have to have a whole bunch of disclaimers involved.
Yeah.
So, just briefly, can you, and you touched on it a little bit, but can you explain the process for like establishing legal guardianship or conservatorship for an adult with a severe mental illness? How does the court determine if it's necessary and the responsibilities or limitations?
Yeah, yeah. So I think I touched on like the adult guardianship thing, but I do want to talk about that's a little easier when you know the child's going to consent to it. I kind of want to talk about when you know the child is not consenting, because that, like, let's be honest, that's the most common thing. And not just the child, like we've all been in a situation, I think, where we had a family member who we deeply cared about or loved. And it's like, this person needs somebody to manage their finances. This person needs somebody to like make sure that they are taking their medication. And I don't want to hospitalize them necessarily. I really just want to help them, but they're refusing my help. But the alternative is to let them like crumble, or God forbid, like take their own life or hurt somebody else, right? So I think the most common situation we see where we have to intervene as loved ones is unfortunately the involuntary commitment process or adult in need of protective services process. I'm not sure if that's what they call it in other states, but in Alabama we call it like an APS, adult protective services, or an involuntary commitment. And so I guess in the most simple terms, an involuntary commitment is also a court supervised procedure, but this is when a person is experiencing like a severe mental health crisis. This is like, think, someone is having a major manic episode and they are a danger to themselves and others. They're unable to meet their basic needs. They haven't showered in 7 to 8 days because, they're just like not mentally stable enough to do so. And they're just like totally raging. This is a civil process. So even though it's an involuntary commitment, it is not a criminal process. And the goal is treatment and stabilization. It's not punishment again. So like same thing with guardianships. The goal is treatment and stabilization. Whereas guardianships are more like long term. Involuntary commitments are to kind of intervene when there's a major crisis going on. And so the process is a little bit different though. Here in Alabama, we file involuntary commitments in what we call the probate court. It's like a lesser court than our typical trial courts. And so anybody can file this. That's kind of the interesting thing also. Like it can be a family member, but it could also be a friend. It could be somebody that you're not even related to. It could be a law enforcement officer. And we do see that in situations where someone is having like a manic episode and they commit a crime and they've been arrested. We will see occasionally a law enforcement officer file for an involuntary commitment if they determine that that person needs treatment. Which, when you have a situation like that, you've got a good law enforcement officer, because instead of thinking like this person needs to be thrown in jail, they're thinking this person really just needs to be hospitalized and get some help so they can be stabilized. And then I've also seen where doctors have filed involuntary commitments, and they're asking that this person either go into some type of treatment or hospitalization, or that there be some type of intervention. And so here's what you have to show if you're going to generally file for an involuntary commitment. You've got to show, number one, and prove that the person has a mental illness or some type of substance abuse disorder. And here in Alabama, substance abuse disorder is considered a mental health, just like it is a mental health disorder. So that's good. I also believe that under the ADA, things like opioid use disorder are mental health disorders. And I've had to argue that ADA argument in criminal cases, I don't know how many times. The other thing you have to show for an involuntary commitment is that the person poses an immediate danger to themselves or others. So that sometimes is the hardest burden, because you do have to prove that that like there is a almost like reasonable likelihood that they are going to endanger themselves or another person, or that they're so impaired that they cannot care for their basic safety. So it's either they're a danger to themselves or another person, or they are way beyond being able to take care of their basic needs, but they're not complying in your efforts to help them. So, you have to involuntarily commit them. So another thing is that if there's like a really, really urgent risk, judges may order a mental health evaluation immediately. If that person, like, we see this most common when people start showing signs of schizophrenia and they haven't been diagnosed with schizophrenia, the judge may order that that person get a mental health evaluation after they've had like a major manic episode, and that a law enforcement officer kind of pick them up and transport them to that mental health evaluation. That's what we call like immediate detention or evaluation. And that's sometimes like a subset of the involuntary commitment. It's not an arrest, it's just making sure that the person gets to their mental health evaluation safely. The other thing that a loved one should be aware of is when you file for an involuntary commitment, the person that's in danger, for example, is appointed an attorney. So just like the guardianship, they are appointed a legal counsel to represent them. And that's supposed to happen immediately. So the courts are supposed to give them their right to counsel as soon as that petition is filed. The next thing that will happen, though, is there will be a hearing held. The hearing is supposed to happen within a few days, because obviously this is supposed to be an urgent issue and it needs to be resolved as soon as possible. And they then kind of have what we call it's a probable cause hearing. So if probable cause exists, then that person is supposed to remain in treatment. And if not, the petition is dismissed. I have only had one, maybe two cases where someone filed for an involuntary commitment and the court determined that there was not probable cause. Both times I was actually representing the ward. So I was representing the person who the loved one was trying to get an involuntary commitment. In one example, the daughter did not like the way her mom was spending her money. So, like, the long story short of it was the mom's husband, like third husband, passed away. The mom inherited a significant amount of money, and the daughter felt like the mom was spending her future inheritance. So she filed an involuntary commitment. So that was like an example of someone taking advantage of the system. But the other one, I think, was something similar. It was like she didn't agree with the men that her mom was dating. And so she said that, she needed to be committed because she didn't like her mom's boyfriends. But in most cases, the involuntary commitment is going to be granted because the person can show probable cause. Now, when we talk about probable cause, or when we talk about the burden of the petitioner, there is an expert evaluation that is supposed to happen. I mean, there is supposed to be a mental health professional conducting a thorough evaluation to determine certain things about the ward. What is the level of danger here? What's the actual diagnosis? Does this person have the ability to make decisions for themselves? And then what kind of treatment is recommended? Is it, inpatient treatment? Would an outpatient commitment work better with an appointment of a guardian? Like sometimes that's how you get to the guardianship, is through the involuntary commitment. And then if it doesn't settle before that point, it proceeds to a final hearing, which looks a lot like a trial. And that's where the judge will hear evidence from the petitioner, the medical experts, the ward's attorney, and it has to be clear and convincing evidence. So when you get to that final hearing, there has to be clear and convincing evidence that that person has a mental illness, that they're a danger to themselves, or they're unable to care for themselves, that they absolutely need treatment, and that there is no less restrictive alternative. So again, the court is always balancing safety and individualized autonomy. They are going to look for the least restrictive alternative to treatment, like inpatient treatment. So, for example, if they can do outpatient, they're going to order outpatient. But if there's no less restrictive means, then they will determine by clear and convincing evidence that the person needs to go into inpatient treatment. And the order from the judge typically looks like, okay, we're going to transport you to a psychiatric facility. We're going to do some other method of stabilization or treatment, and then they're going to designate how many days the involuntary commitment will last, including monitoring, the local mental health center's involvement. DHR is often involved in those cases. And then also sometimes the appointment of a guardian. If they do get stabilized, they may be appointed a guardian for a temporary or permanent amount of time.
Wow, that sounds like quite the process. I can understand now, just from dealing with some siblings who have mental illness, and we've had to go through the process when they were adults, the push to get them to voluntarily go in. We had to do that multiple times with one of my siblings, go in for the 3-day hold to get stabilized. We had where we would have to call in law enforcement, and then a trip to the ER. And then from the ER is where the evaluation and all that would take place. And then they would go in for a voluntary
Right.
time. Now, when you're dealing with, like, you're a parent, okay, and you have, say, your 19 or 20-year-old, and you get them to go in, do you have any rights, or does that person who had to go in, how many rights do they have if they say, I guess, involuntary versus voluntary? And can they say, okay, I don't want my parents to have any knowledge of what's going on with me inside here? How does that all work? And how, as a parent, what do you do?
Yeah, so it really depends on the judge in that situation. And that's kind of the hard part is like, I always say, like, if you cannot leave it up to a judge, anything, I don't care what it is, don't, because the judges don't know your family like you do. And so, I mean, well, I think the first thing to say, especially as someone who has defended wards before as their appointed counsel, they have rights, right? They have rights to some degree of privacy. They have due process rights. They have rights to a hearing, and they have rights to an attorney. And so, because the court is always trying to balance the individual autonomy of the person who's being involuntarily committed, they do have the ability in some instances to walk away. Now, if the judge puts an order that mandates this person to comply with the terms of the order, then they can get in trouble for, violating the orders of the court. But what you described earlier about always trying to see if the adult will agree to the treatment, that is always the goal, because if you have to proceed to a trial, that's a hard day that you can't come back from. Like, watching families go through the final trial, if the ward fights it to the end, which they have the ability to do, like they can fight it to the very end. That just ruins families. Like, it because the thing is, your deepest, darkest secrets are being, like, on full display in the courtroom, even if it's just to the judge and the attorneys and there's no one else in the room, which often that's the case. Like, everything gets exposed at that point, because remember, the burden is clear and convincing evidence. So the petitioner, if you're the loved one who's trying to get the commitment, you have to, it ain't no reasonable doubt. It ain't no probable cause, no preponderance of the evidence, more likely than not. It is clear and convincing evidence. So you've got to put that person on full blast about every bad decision or mistake they've made while under, under the mental illness or substance abuse. So the person has a lot of rights up to that point, though, because again, they haven't been determined that they actually need a permanent or an actual involuntary commitment. The court has obviously the authority to temporarily stabilize them, like you said, for a few days and this and that. But I mean, they maintain their rights technically, up until that final hearing. Now, once the court orders what it orders, that person is supposed to comply. And I have unfortunately seen situations where the person didn't comply, and, they went to the hospital for a time, but they ultimately ended up in jail because of just a complete disregard. And that is, again, kind of a flaw in the system of, we treat things like it's supposed to be punishment as the goal, but it's really supposed to be treatment and stabilization and rehabilitation. Like, in many situations, like substance abuse, which we know is a disability, it is an actual disorder defined under the ADA. People forget that the goal really is rehabilitation and not punishment.
Right. So that's all very extreme. Is extreme circumstances. Are there less restrictive alternatives to like full guardianships and like power of attorney?
Yeah, absolutely. So, well, the hope is, like, if having to get the court involved usually means that it is an extreme situation. So here's what we do sometimes instead. Let's say that, okay, here's a good example. Let's say that you have a child who is 19, and, like, they don't have any significant mental illness. Maybe they have just, like, generalized anxiety. It's not super severe, and they're about to go off to college. And there are some situations where the child is like, I am not comfortable, like, doing some of the things that I need to be able to do from, like, a documentation perspective, like, as I'm in college and this and that. I would much rather my parents do that. And they have like the mental capacity and the lucidity to grant their parents the right to do that while they're technically an adult because they're 19,
Right.
or 18 in another state, but I always think of Alabama. We will often see children who don't have severe mental illness grant their parents powers of attorney while they're in college. And this is kind of a common thing that we do at our office because we have a lot of like staff who have kids that are in college. And so they will grant their parents limited powers of attorney to do things for them while they're in college. And this is really important when your child goes to school out of state. Like, this is like incredibly important because if something happens and you're a parent who needs to get access to the doctor or to medical records or to the school or whatever, and the school's like, well, they're an adult, like you can't, you have no power. This allows the parent to be able to do what they need to do. And so I always recommend, like, if your child is college age and, or even like you have a child that lives out of state and they're single and like, you know, like something, anything could happen. It's not a bad idea to consider granting your parent a power of attorney for a limited time. It doesn't, and that's the thing, people don't realize a power of attorney doesn't have to be all encompassing. Like, it doesn't have to include all the powers. It can be limited. You know, it could be just for filing my tax returns, filing a FAFSA on my behalf, getting access to my grades, getting access to my medical records. You know, like, you can give very limited powers. And so that's one of, I would say, the least restrictive ways for children, adult children, to give their parents power when they still have like the mental capacity to do so. And we see that quite often. The other thing, though, when we're talking about like court involvement, I've got a good example actually. So I had a case where someone was filing for an adult guardianship of their mother, and she was showing maybe like stage 1 signs of dementia. I mean, you know, definitely showing some stages. But she was definitely, like, she was still working, she was still driving. She wasn't like, she was able to take care of herself and able to still pay her bills and things like that. She was the victim of a couple scams and like definitely some elder financial exploitation, which I'll just be honest, with AI and deep fakes, that's really easy to accomplish these days.
Agreed.
Like, you don't have to be an elder. You can just get scammed, right? So I do know that well, I argued on her behalf that a guardianship was not appropriate at that time. You know, a conservatorship and guardianship was not appropriate. That we needed to do something least restrictive. And so Alabama has now a statute that allows, oh, and I can't remember the exact name of it, but it is where the person who they're claiming needs a guardianship and conservatorship can enter into a voluntary contract, basically, with an assistant. Almost, it's literally like you pick someone to serve as your like a consultant almost for you, so that like if you want to consult them about decisions, you have the ability to do so. And it's not unilateral. It's both of you, the consultant and you, have to agree to enter into that agreement. And the specific scope of what that person can consult on is outlined in the agreement. So for her, for example, hers was financial decisions. Like, she would consult this trusted friend, and it was like a trusted friend that she had known for many, many years, on all of her financial decisions. And then that trusted friend also agreed to serve as that consultant. And this is a very recent statute that Alabama passed within the last 2 years. And I wish I could remember it off the top of my head, because it's something that from a policy perspective, all states should consider. But that was a way for me to avoid a full-blown guardianship and conservatorship over this woman who really had the ability to maintain at least for the time being, her individualized autonomy. And here's the other thing, the court was able to set status hearings for like annual or 6 months at a time to check on the status of her financial situation as she was paying back some of these debts that she had taken out pursuant to the scam. So, like to try to fix the debts. And so that is an example of a least restrictive means also that is available to at least people in Alabama.
So if
And
you're looking
wholeheartedly,
at,
go ahead, Delisa.
oh, I'm sorry. If you're looking at, say, long term, because these are kind of long term, you have someone with a long term mental illness in your family, and you want to make sure that they are taken care of. What about things like special needs trust
Mhm.
or supplemental needs trust when your person gets older? I have someone in my family, a sibling who's older than me, and that's something that we had to establish because she has a lifelong mental illness that she battles. Can you kind of walk us through that process and how it helps the family member and also the person who's battling the mental illness?
Absolutely. I do a lot of
Be-
special needs
Before you
trusts.
go into the long term, I want to kind of close a loop on a question at the power of attorney part.
Yep.
Does that, on a limited kind of thing, if something were to happen to the person and they would pass away,
Mm.
does the power of attorney then like avoid probate and wills and things like that, or that all still comes into play and it just kind of ceases to exist because the person passed away?
Yeah, so that's a great question because that is a common misconception I hear from clients, or the question that I get from clients is like, "Hey, I had power of attorney over my loved one." And I'm like, "Okay, great. Where do they live?" And they're like, "Oh, they're deceased." And I'm like, "Oh, okay. Well, the power of attorney technically dies with them." So I will say though that if you make it a durable power of attorney, we call that like a DPOA, it survives incapacity. So if the person becomes incapacitated, the durable part is what survives incapacity. But when that person passes away, that power of attorney passes away with them. And so that is an excellent question, because that is a common misconception that people don't understand. And so for that reason, you've got to also plan for after death. And, it's like this whole morbid conversation people consider it to be. But I always say, like, death is inevitable. And there's this great quote from Mr. Rogers about, anything being mentionable is manageable. So if we can talk about it, we can manage it, but we have to be able to talk about it. And so that's where a last will and testament really is important, to nominate a personal representative or a special needs trust, and appointing a trustee. So and I also want to say something real quick. I remember the name of that document that's the least restrictive document as opposed to a guardianship and conservatorship. It's called a supported decision making agreement, an SDMA, supported decision making agreement. The act that we have in Alabama that got passed in 2023 is called the Colby Act. And again, it's so that people can choose supporters to help them make decisions. This is like monumental in our state because, like, people being able to maintain some level of autonomy is just so important when you have people dealing with mental health issues. And so this was a really great opportunity for our state to pass something like this. But I think there are other states that have something similar, if not the same name.
And now I have another question about the POA.
Yeah.
How would you suggest that parents talk to their children about the POA? Because I'm a firm believer, like you, if your child is going off anywhere where you can't get to them, they need to have a POA. But also because some of these mental illnesses, like schizophrenia, they tend to manifest when about 20 in their 20s, and sometimes they are in school.
Yeah.
So how do you how do you have that conversation? How would you address that? Because you're an irritated kid. Oh, I'm fine, mom. I don't need that. Nothing's going to happen to me.
Yeah,
You
yeah.
know.
You just want to
There and
maintain control over me.
Right.
right,
You're just trying to
right,
Be
control
up in
me,
my
mom.
business.
right.
Yeah.
How would you suggest you go around having that conversation?
Yeah, yeah. So, I mean, I can, again, I don't have my own kids, but I can speak to how I've seen like my coworkers have the conversation with their children. And of course, we're like a firm of legal professionals. So I think the kids expect, they're entering into contracts about moving back in with mom and dad after college most of the time. But for what I've seen that works the most is treating them like an adult. Like honestly, it is truly like a sit down of, okay, we are two adults or three adults if it's mom and dad or mom and mom or whatever. And we are having a conversation as adults about boundaries and realistic conversations about safety. And so allowing that child to have a say in what the boundaries actually are, because I think you're going to have more success if you approach it like, okay, these are my concerns. You're about to go off to school in Louisiana or wherever. There is no one there. You have no family there. We need to make sure that if something happens, I can do the things I need to do to protect you just to protect you and your estate and all this other stuff. Um, Here's what I think, this is what I would suggest, but I want to get your input on what you're comfortable with, and lay it out very simply. I think that, first of all, I'm paying for you to go to school. The deal is that you're not going to have to take out student loans. We're going to private pay for you to go to school. But the deal is that you're going to have to work part time and I'm going to have access to your grades. So, in order for me to have access to your grades, I need a power of attorney granting me that access to your grades. Is that reasonable? So that you don't have any student debt when it's over? Are you agreeable to that? And almost like, like it's a bartering system. And I mean, you would think that a child would be like, well, shoot, if I don't have to take out student loans and you're going to pay for it, sure. If you can explain that. But the other thing would be like from a true safety perspective, if something happens to you and you get in a car accident, God forbid, I need to be able to do this, and this. Are you agreeable that I can do these things and have access to these things while you're in school, like while you're out of state? And really taking it and making it practical. I understand that you don't think that's going to happen, but this is the statistic. And I need to make sure that you're taken care of. Now, here's the thing. In the back of your mind, you're also thinking it may not be a car accident. It may be that a person schizophrenia starts to develop. But these are the same things I would need to be able to do. I would need to be able to access medical records. I would need to be able to get in touch with the physician. I would need a medical healthcare agent appointment. I would need to be able to do these things. And you're making it real for them, because a lot of times kids they do know a friend who's been in a car accident. They do know some situation like that. So you're making it practical and realistic for them. And then you're kind of going over the scope. Okay, so do you think this is too restrictive? Are you comfortable with this? Listen, I promise I would never use this information to harm you or to try to control you. You're giving them the reassurances and letting them have a say in the process. But you really are sitting them down and saying, we need to talk to you about this from a collaborative perspective. I'm not trying to force you to do anything, and I can't force you to do anything, but I care about you and I want to protect you. And there's just too many instances. I mean, we see them on the news all the time where like something happens and the parents are having to go through a million channels just to find out what they need to find out. So that would be my suggestion. I know that's not going to work for every family, but I think that would be a good option. The other thing I'll say is that if the child is in active therapy or counseling, that's a great topic for like a joint session. Like, that
Oh,
maybe
that's a
like
good idea.
right, like a third party could facilitate the
Mediator.
conversation. and then like bring the parents in of like, hey, just as part, like, you're not going to be here to do your in-person therapy appointments anymore. I think we need to talk about some limited power of attorney, and what are you comfortable with? Now, what are you all comfortable with? And almost serving like a facilitator and a mediator in having that discussion.
That's a great
And that is a
idea.
great idea.
Do you have to have an attorney involved in a power of attorney, or is it something that it's like for those that might be thinking, I can't afford to go out
Mhm.
and hire an attorney to go through all this process, but it's as simple as just writing something up with maybe with some legalese, or there are templates online in certain areas that just outlines what the specifics are, and maybe have it notarized, and you
Yep.
each have a copy of it, and
Yes.
that's it, right?
So what this is what I recommend. Of course, as an attorney, I always recommend you have an attorney draft it because they're going
Right.
to think of like additional language that may need to be included, but it's not necessary. Like the law does not require that an attorney draft it. So my biggest piece of advice would be just make sure that the execution, the signing process complies with the law in your state. So, or well, I would say the law in your state and the law of the state where the child is going,
Mhm.
because you don't want there to be any confusion. And so here's what I always recommend: two witnesses and a notary, like just to be safe. And these witnesses have to be disinterested people. Like they can't be the parents that are getting the power of attorney. It needs to be disinterested people, and then a disinterested notary is the safest thing you can do because every state has different execution requirements, but that is probably the safest way to make sure that you've probably complied with them all. So
Okay.
that's the most important thing, is not necessarily who drafts it, but how it's executed, and does it comply with the law in your state. I'll be honest, with AI now, I mean, you really could go into Chat GPT and say, I need to draft a power of attorney for me to have access to my child's grades, make sure it's, in compliance with this state's laws, and, give me a draft and put two witness signatures and a notary. Like you really could kind of draft that and it probably be reasonably enough sufficient to do what you need to do. My only concern would be when we talk about medical powers of attorney, it is always better to have an attorney draft it because like our medical and financial powers of attorney are like over 20 pages long. Like they are very inclusive. This is mainly for people who are I mean I have one and I'm only 34, but I'm thinking like if I go into a vegetative state or have like a terminal illness or
Mhm.
something, I need to know that my appointed people have full power to do what they need to do. And I want to add one more thing to that. The other thing that people have options for is you can make a power of attorney springing. Okay, so let me talk about what springing means. Springing means, well, there's two types of these powers of attorney as far as when they become effective. There's a present power of attorney that is effective immediately. And then there's a springing power of attorney that springs into action when a certain event occurs. That event is typically mental incapacity. So this is where, like, and this is what I have. Right now, I can manage my own financial and medical affairs, no problem. But if two physicians determined that I was mentally incapacitated, this durable power of attorney will spring into action automatically, and my appointed agents will have the power to do what they need to do. So that is another option when we talk about powers of attorney. My only concern when we're talking about kids going off to college is my opinion is that they don't have the maturity at 19, 18 years old
Exactly.
to be able to make these decisions for themselves. Like they just don't, right? So I think it needs to be present. It should be limited in what the scope of the powers are, but it needs to be present. And then my other concern about kids going off to college is we don't have time for two physicians to determine if they're mentally incapacitated. Honey, I need to be able to get to my kiddo right now. Like I don't have time to
Mhm.
wait on this physician or these two physicians. In my situation, it's different. I'm 34. I have a husband. If something happened, like I feel like I'm in good enough shape that, like, I've got people here with me that if they needed to do what they needed to do, we could wait for two physicians to come and say that, whatever. But with the kids, I always recommend present. But I do want to bring to everyone's attention that there are springing powers of attorney that will go into effect at a certain point. And that's more appropriate when you have a mature adult that's not dealing with any significant mental illness or cognitive issues.
That's a great distinction. Thank you.
That is. So now then going into long term, where you have this family member or
Oh, yeah.
whomever, long term mental health issues that you as a family member are working towards when you're looking at the special needs trust
Yes.
or the supplemental needs trust. Tell us, why those are important and what they can do for both the person who's living with the mental illness as they age and the person who is taking care of them.
Absolutely. So special needs trusts are a great tool to protect a loved one's benefits. Okay, so when we talk about benefits, we most often think about Social Security benefits and Medicaid. And as we know, there are mental health illnesses that qualify under the federal recognition of disability. And so sometimes people with mental health disabilities will be on SSI or Medicaid or Medicaid. And so I want to give a really practical example that I dealt with last week. So I had a mother who was in her 60s. She had a certificate of deposit, a CD, that held about $150,000 that had been inherited from her mother for the benefit of her adult child. Okay. So the way that the attorney recommended that this money pass down to this child was that the parent just deposit the money into a CD and then manage that money for the child. Like, don't worry about it. You'll have full control over the money. You can spend it on the child how you see fit. You don't need to put the child's name on it. And this child is an adult. Like, this is, an adult child. So she does that. She puts the money in a CD, she puts it in her name alone, and she's just like giving the child the money when she needs it for her health, safety, and education, this and that, blah, blah, blah. So this mother comes to me for her estate planning, which, she's in her 60s. It's definitely time overdue to get her estate planning done. And I start doing what I call Medicaid planning for the mother. So I'm like, hey, we need to protect your assets from any potential Medicaid claims in the future. If you ever need to go into a nursing home, let's start doing what we call the Medicaid spend down. And she tells me about this $150,000 that is technically supposed to be her daughter's, but it's like in her name and attached to her name in the event that, Medicaid ever went back to look at her assets. And so I said, listen, we need to do a special needs trust for your daughter. Now, her adult daughter has mental health disabilities, so no physical ailments, all mental health. I think personality disorder, bipolar disorder, like several disorders like that as defined under the ADA, and was in the process of getting SSI. So what we did was we created a special needs trust, and the mom was then able to put that money, that 150,000, in the name of the special needs trust so that her adult daughter would not be disqualified from SSI, but she could still use that 150,000 toward things that the adult child would want. And I want to give it a distinction here. So sure, that this child would be able to get SSI for her basic health and safety needs. But this 150,000 was an inheritance from her grandmother that could be used for things like travel, extracurriculars, vacation, all the things that you can enjoy from an inheritance, a girl's trip to Vegas. I mean, just whatever she, wanted to be able to spend the money on. But the special needs trust ensures that, and it's also sometimes called a supplemental needs trust, ensures that her supplemental needs can be met and she can still qualify for her disability, for her safety and health needs. And so it improves their quality of life. That's what we're always thinking about is, um, we can use these extra assets to improve the person's quality of life in the same way that we have discretionary income to improve our quality of life. We want to get our nails done. We want to get our hair done. We want to go on vacation. People with mental health disabilities should be able to enjoy those same luxuries if they have the means to do so. And so this allows them to have the means to do so. And so a lot of loved ones will create these special needs trusts for people to be able to enjoy their quality of life. So there's two types. We've got a first party trust. This is funded with that person's own money. So the person who has the disability, let's say that they are working a job, or, oh, better example, they're getting alimony. I give that example because I have had many spouses who have been married 25 plus years. And again, as a general practitioner, I do divorce also. And so they have a disability, a mental health disability. They are also granted alimony when their husband leaves them after 25, 30 years, but they don't want to be disqualified from their SSI. So we will do a supplemental needs trust or a special needs trust where the alimony will go into that trust, and be protected. So that's an example of like a first party trust. And then we have third party trusts. Those third party trusts are funded by loved ones, often parents and grandparents. And the key idea is you don't leave your assets directly to a disabled child, because even a small inheritance can disqualify them from essential services like SSI or other like state provided services. So the special needs trust just really serves as a tool to protect that money for the benefit of the adult child or the disabled child.
Awesome. So many things to think about and consider that you don't, it just,
Yes,
the thoughts just don't even enter your mind.
I know. I
And
know.
I know we've gone like way over what we had planned time-wise here, but I just have one question with regard to accounts and stuff. And again, going back to the power of attorney, or in case someone becomes incapacitated or passes away. Isn't there certain ways that you can set up accounts,
Yeah,
like
absolutely.
not like payable on death or transferable on death, I think is what it's referred to now. Can you speak to that just a little bit before we wrap up here?
Yeah, so on the note of the special needs trust, the language of the trust will often say what happens with the money when the recipient passes away. So that's one thing. One way is that if any of those accounts are in the name of the special needs trust, the terms of the trust will talk about where that money goes in such a way that avoids probate. So that's kind of the benefit also of it being in a trust, is that it will also avoid probate in addition to it being protected from SSI and Medicaid. I also want to add though that there are things like ABLE accounts, the Achieving a Better Life Experience account. It's kind of like a tax advantaged savings account for people with disabilities. A lot of people don't know about this. It is a really powerful tool for families to protect benefits while giving their loved ones financial freedom. So that's something that people should look into, is that ABLE account. It's similar to like a 529 college savings account, but it's for disability related expenses. And again, like you can do payable on death type designations, so that that money avoids probate if something happens to the person. It does have like contribution limits similar to a college account, but those monies can be used for things like housing, education, transportation, therapies, mental health treatment. I mean, just all kinds of stuff. So I wanted to touch on that real quick. But you're so right. On bank accounts, just like with anybody else, if you're looking to avoid probate, a disabled person, as long as they do have some level of control over their financial affairs, can name payable on death designees on their accounts to ensure that the designee can get access to the money upon their death. And I always recommend avoiding probate if you can. And so if you can do things like name beneficiaries on life insurance, name beneficiaries on retirement accounts, name beneficiaries on trust accounts, and successors. It's always good to name successors in case your intended beneficiary passes away before you. That's always going to be better than having to probate a last will and testament and go through the probate process. Because here in Alabama, the probate process is typically 9+ months. It takes some time, as opposed to having a payable on death designee where you can get access to those monies immediately upon the death of someone. So I absolutely recommend that.
That's such a great idea. And to make sure, I'll just add, 'cause this is something that I do, to make sure that you're checking up on your POAs every so often, because sometimes you put them in there and then you forget about them. And then, you've had the same POA for 10, 15 years and then something happens. You're like, oops. So that might be, make sure that you are looking into your financials on a regular basis and updating those beneficiaries as needed. This has been
100%.
just such great information.
Good.
And even on accounts and stuff, like if the payable on death or transferable on death is a great way to go if you don't want to give the person any kind of access to the funds or
Yeah.
control over it versus a joint tenant with right of survivorship setup, which is like how most married couples are,
Yep.
correct?
Yes, yeah. So the joint owner thing, we see that a lot. And I often don't recommend it. Not for married couples. I don't care about that. Like me and my husband have joint accounts, but I really am uncomfortable personally, and I guess it's because I'm a lawyer, with parents being joint owners on their children's accounts. There's lots of reasons for that. And I'm talking about joint owners on adult children's accounts. Number one, again, I see like some of the nastiest family dynamics you could possibly imagine. And I've seen situations where parents pull all the money unreasonably from the account because then joint owners, you have full and equal
Right.
control. The other thing though is that I've seen situations where like there were unintended circumstances in those situations where one example I saw was that a parent was going through a divorce and they were on all of their children's bank accounts. And so like all of the joint accounts became subject to the divorce. And it was like a question of whose assets were whose. And so now the adult child's assets were all held up in that. Another example is, God forbid you get in a car accident and you get sued with a personal injury lawsuit. Now all of this child's assets are held up in this personal injury lawsuit, and there's like a spoliation, you can't spend that money, you can't waste it. So I worry about like the joint owner thing. As an alternative, the power of attorney is the best way to go. Like the financial power of attorney is the way to go, as opposed to joint ownership on accounts in those types of situations.
Okay. Great. Thanks for clarifying that.
Absolutely.
All right. Well, I feel like I've been to college and back in the last hour and a half.
It's so many topics. And like honestly, we branched off such that I was like, ooh, that would be a good podcast topic. Ooh, that would be a good several. There were like several times I was like, man, we could have like 4 or 5 episodes, honestly, on all the things that we covered in this episode.
Well, make note of those because we are under no restriction to not have you back, however many times it takes.
That's true. It's just so important with all this legal stuff when you're dealing with mental illness and you're dealing with having to, the times when you have to take action and you really need to know what you can do and what you can't do, what your rights are, what the person's rights are who's going through the battle, because that's something that they're really afraid of a lot of times, especially if you're dealing with someone who's already in a manic state. Oh, you're trying to lock me up. You're just, so I'm so glad that you could come on to kind of hash this out for us, because yeah, there's so many questions. Thank you
Yeah,
so much.
absolutely. No problem. I just appreciate y'all for being so concerned about these issues, because I'll be honest, like I didn't know there was even a podcast about these topics. I mean, I'm sure there's thousands of podcasts, but like this is such an important podcast. Like, this is an important topic that people should really think about, because you don't think about like, oh, this could be me, this could be my family, this could be my son or my daughter, until it happens to you. And so everyone should be aware of the topics that y'all are covering in your podcast.
Wonderful. Thank you. Well, we would happen to agree with you on that wholeheartedly.
I love it.
And thank you for being such an advocate and giving a voice to some of those that don't normally have a voice in the
Absolutely.
process. So, all right. Well, that's it for this episode of Glow for Hope, sparking conversation on mental health. Until next time, keep shining. Thank you for joining us on Glow for Hope. If today's conversation resonated with you, share it with someone who needs to hear it. Remember, your mental wellness matters, and you are never alone. For more resources and support, visit glowforhopenfp.org. That's glowforhopenfp.org. Stay connected, stay hopeful, and keep the conversation going. Until next time, keep shining.
This podcast does not and is not intended to provide medical advice. The information presented on this podcast should not be interpreted or construed in any way as a replacement or substitution for medical advice. It is important that you discuss your condition, treatment options, or any questions that you may have with your doctor or healthcare provider.